You just cannot understand what is happening. Whether they even delay it after the legal vacation, will the trial stop? It will still continue. So even when you bring those particular instances, it's still not justified. Okay, granted, that fine, the legal vacation, the chief just said, okay, so no cause to sit. Let's adhere to the legal vacation, after which will those cases won't come back to court to defend it. So what is it? What is it? But anyway, let's move on.
Whenever I say my PENDREAM TV there, I see them yopo.
Mujib Abdul Rahman, a NPP communication team member. Now, we Pia Bontain Abekatse. Me party no, enyina kasa atia the court sitting on a legal vacation and as a speedy trial. Name the truth must be told. Yentimi fa bibia enye politics. Enye issue bia ena was a politicizing. Mujib Abdurrahman HSM. Adia Chief Justice Bafo Boni ayeno enye adefofro. Na on tiasientia NPP for sopano. Specifically almost like to say adenti and a Chief Justice Bafo Boni. Apeke choose a certain cases. Yeah, say those cases should be heard in this legal vacation. Mujib Abdurrahman bisa say, and think a case is being Enna a Attorney General and as a Chief Justice, the NTSR cases no in this legal vacation. Even if Chief Justice Bafo Boni granted a Atta any other lawyers or more protest or more so more legal vacation into more backward into more adjourning cases no. Now, Montana cases no so after a legal vacation. Granted, if said Chief Justice Bafo Boni, Emma Omo sa privilege now. After a legal vacation, no. After all, the cases are still going to continue. And what is it? A day any day, a day any protest a good way, a day any propaganda, ya omo true agu a Ghana for any so. In fact, stance Mujib take care on a NPP attacks on Chief Justice Bafo Boni no Emma Kwesi Pratt Jr. Ebo na baso for ne stance and now say no crea oka regardless of he belonging to the NPP amanyoko. Yenti Kwesi Pratt Jr. Yewia na ya toaso ati ensema Mujib Kyea ama Kwesi Pratt Jr. Ebo na baso.
Is it Pratt?
Well, I mean, look, the point has been made. And first and foremost, I'd like to commend our fellow panelist Mujib for always, trying as hard as he can to speak the truth as he understands it. I mean, this morning, he has made the point very, very strongly that as far as he's concerned, and in spite of his membership of the New Patriotic Party, the Chief Justice has not erred in law in this matter. And I think that that's a very commendable, position to take.
In fact, Mujib Abdurrahman asoja agu ono ankasane party members omo atake a Chief Justice Bafo Boni on a speedy trial and as a court sitting on this legal vacation. Now you hear the details from Mujib Abdurrahman.
Mujib?
Yeah. Thank you very much. I am really confused. I just don't know what to say because, like Prof mentioned and quoted, this shouldn't have been an argument because it's backed by law and it's even there's a convention. But I think, we are here because it's purely politics. And I said it's politics of convenience. You take it where you think it is convenient to me. You want to spin on it. But people's life and freedom and liberty are at stake here. So we all know, for the issue of vacation or leave to go and rest, it is part of our working culture, which the courts are not exempted. And I've also gone through some literature on this, and I've asked some judges, and this is not the first time. But I ask myself, like, I am in a fix because I really don't know. But if you look at those challenging, they are even narrowing it down to particular cases. That is the reason why the Chief Justice at this time have decided to ask some courts to operate within the legal vacation. If you want to go by that narration, it means that the contention is not the legal recalling some courts to sit on some case or to sit and administer on some cases, but the particular cases involved. And I just try to look at it generally, looking at how it is. Which case will you have been happy for the Chief Justice to allow this to happen? I hope you are getting the argument. But I know where I'm coming from. I don't want to fall into that pit of just trying to narrow it and look at it. Because the point is, people must be account for their stewardship. People who were fortunate to be given public appointment should be ready to account to the people, irrespective of who it affected. That is my principle. I hope you are getting the argument. But at least, even it will be in the interest of those people. So don't take even an expedite action. Maybe if you believe you have a case, if you believe you can defend your client, but let's don't play cha-cha with people's rights and liberties. It is very, very important. I hope you are getting the argument. So for me, I want us to leave the political aspect of playing politics with it. But there's nothing wrong with what the CJ has done. He's not the first time who has done it. If you go past, we have seen CJs that have done it. And it is not new. But this time around, those who are challenging the lawyers who are making noise, it is because maybe they are saying it is because of their particular cases. For instance, Boahen. And I ask myself, what is so special about it that you don't want to represent your client because it's legal vacation? It is putting your clients in jeopardy. And if you think maybe you can't do it at a point, you have to be sincere and genuine to your client. And it is the right of your client to look elsewhere and get a legal counsel, which is very, very important. But I'm looking at the case whether those affected can decide not to appear before the court. And if that happens, they are putting themselves in trouble. So now we have, I think we have serious issues than some of these things. But I think that those who are also making raising their issues also have their rights. But I think that cannot stop what the Chief Justice has directed so far. And even in the interest of those who are standing before trial, it is also in their interest to appear in court. And I will also appeal to the legal, the counsel of this affected individual and the legal firms. And since when the bench and the bar are two distinct institutions, so I think this time around they have decided to come to the aid, but to come together, support the Ghana Bar Association to petition. And I don't think that, I think that should have been the best way to go. But looking at whatever it is, the bottom line is that the CJ has not erred. He has done the right thing. It depends on you whether to still go defend your client as a fiduciary responsibility duty to do, or if you think you can't do it because you want to be outside cooling off, you have to be very candid to your client, and he has the opportunity, the right to look for a different counsel. But you don't put their life in jeopardy. But this whole thing, my brother, it is politics people are spinning. They know the truth. There's nothing unconventional, there's nothing unconstitutional about these things. I hope you are getting. So sometimes we have more important issues that is affecting the life of our people every day. That should be concerned about us. But why? People must be tried. People might be answered for what? For their stewardship. That is not a new thing. Others have gone through it. So nobody is special. And sometimes they put some of us in a situation that you just cannot understand what is happening. Whether they even delay it after the legal vacation, will the trial stop? It will still continue. So even when you bring those particular instances, it's still not justified. Okay, granted, that fine, the legal vacation, the chief just said, okay, so no cause should sit. Let's adhere to the legal vacation, after which will those cases won't come back to court to defend it. So what is it? What is it? But anyway, let's move on.
Mujib ede nensem ebetu dwano. Lawyer Apia Dankwa of a movement for change, and so ebe kasa efa a NPP's attack on a court sitting on Boahen any other cases in this legal holidays. Now say a lawyer Apia Dankwa a can answer.
I've been a lawyer for 18 years. And I can tell you that litigation is just a small bit of a lawyer's job. So if you understand it that way, then really you ought to understand that there's legal vacation was not created for us lawyers. And that's why there's really no vacation for the lower courts. And the lower courts, still lawyers that go there. And so if the whole idea of legal vacation was meant for lawyers to rest, then why would there be courts that lawyers will go to? Because the lower courts are always opened, and they are designated vacation courts that lawyers are meant to go. Now beyond that, so if you're a lawyer and then you are advising a transaction, or you are preferring legal advice, are you going to say that you are on legal vacation, so you as in lawyers on vacation? No, that's not how it works. Now, you ought to understand, if you read the Constitution, when we give the judicial powers of the state to the judiciary, and then we create the CJ, we give them one judicial power, but they also have administrative powers also. You understand? And when you understand that this system that we are running is a constitutional democracy, and the focus of that is that we are going to limit powers of government. That the powers that are being limited are not just the powers of the executive, nor the powers of parliament, but also the powers of the courts are limited. And that's why the first thing the Constitution does is to set out in clear terms the jurisdiction of each court. You understand? When we say jurisdiction, what we mean is that power is the authority. You understand? The Constitution says that first of all, it's give them all judicial powers. And two, it says that, listen, when it comes to, let's say, the High Court, when it comes to original jurisdiction over all civil cases and over all criminal cases, it lies with the High Court. You understand? Now, those powers that the Constitution, the people are going to give the High Court. They also have powers of review powers. Some of the like appeal court has appellate powers. High Court has supervisory jurisdiction over the lower courts. Supreme Court has supervisory jurisdiction over, and so many other powers. First question is, do those powers go on vacation? The original jurisdiction to hear all civil and criminal cases, do they go on vacation? The question is an absolute no. So they always have the jurisdiction to hear all matters. Now that's the first point that ought to be made. The second issue is because their powers are also limited, and clearly delineating their jurisdictions limits their powers. So they know the cases that they can hear and not hear. The Constitution went ahead and also limited their powers in terms of in terms of how their jurisdiction can be invoked, and in terms of what they can, the scope of what they can do. And then in Article 157, it set out a committee. The job of that committee was to set out the rules of procedure that ought to be followed in how they exercise their powers under our Constitution. And the duty of the court committee under Article 157 is to set out rules and also set out dates and issues that concerns also vacation. You get the question. Then we have an act, the Cause Act, and under the Cause Act, this same committee's powers is re-emphasized, is reiterated, and then further and better particulars are granted. So read section 80G, I think, of the Cause Act, and it says clearly that the court committee has the powers to set, including what, vacations and all. It didn't end there. Then the court committee then came out with the CI 47. And in the CI 47, there is a portion called vacation. I think Order 79, Rule 4 speaks about vacations. Now, when you read the 79 Rule 4, it makes everything in that provision subject to Order 79 Rule 1. Not so. We have it makes everything there subject to Order 79 Rule 1. Now, what does Order 79 Rule 1 say? It says that, in fact, it doesn't what okay, there's so I can, at least we can read and be clear. This one, and see, in this country, we tend to give lawyers too much credit. When I say we tend to give lawyers too much credit, as in, this is in plain English. We can all read and we can all understand. Seriously. You understand? When we read 79:1, what is it? Oh, this is a constitution. Oh, sorry. Order 79 Rule 1. And to paraphrase, I wish I could, so at least we all see clear. See, the CJ has been given the powers to determine the dates, including vacation. Do you have it? So I read it to you all. You see that it is. Okay.
But you have to stretch it
a bit. Okay. So 79:1 says, subject to the Courts Act 1993 Act 459 as amended, the Chief Justice may appoint any day. It didn't say some day. It said any day. It means that any day may include 25th December. Any day, including vacations, for the hearing of causes. It didn't say for the hearing of. It didn't specify for the hearing of motions or interlocutory issues. It says of causes or matters as circumstances require. So the sitting of the court shall be for such hours as the Chief Justice shall direct. Now the four which the NPP has depended on, says subject to Rule 1. It says subject to Rule 1:1. The following period shall be observed in the High Court as vacations. The period commencing on a Tuesday immediately following blah 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 blah. I think, Senna, this is clear. The Chief Justice has the power to say that, listen, insofar as this case is concerned, I think that 25th, what's it called, December. Go and yeah, I'm so pumped up that I want to leave. So you see the state of the of I'm scandalized by how this matter is being handled. You understand? The CJ can do that. You understand? But even in this case, or drawing practice, so generally, so this is how it works. So on the 31st of July, the court goes on vacation. Then the CJ would then determine that, listen, because matters can happen, I agree, emergency issues may occur for the courts that are, because and the vacation is just for the superior courts, so High Court, Appeal Court, Supreme Court. I'm going to set up some courts, you understand, and I'll appoint some judges there who serve as vacation judges, and they can hear causes and matters. They didn't say they can only hear motions and interlocutory matters. So the court, the CJ does that. Now, because there's a high propensity that these judges may be judges that are not, or we're not handling hearings. We're not handling hearings. You understand? They limit themselves to just motions and not the hearing per se, because ideally when it comes to hearings, especially criminal hearings, there's a reason why the judge who started the hearing must be the one who sees it through to the end. You understand? So the convention has been that they hear motions. That has been the convention. But there are a lot of instances where a judge can say that, listen, I've started this hearing, I want to see the hearing through during the vacation period. Now, when a judge takes that decision, all that is required of the judge is that the judge seeks permission from the Chief Justice You understand? To allow that judge to sit during the vacation period and hear the trial to the end. And I'm saying that there have been so many, I've been involved in some, there have been so many instances where trials have continued during the vacation period. It's not like this is the first time this is ever happening. It happens. You understand? And when it happens, it's not as if the CJ is acting ultra-virus his powers. There will be an issue if a judge does this without the permission from the CJ. But once a judge, because mind you, it's not the CJ that determines that what's called determines the date for adjournment. That power is within the judge hearing the matters control. So a judge can say, listen, because of my own diary, because of the nature of this trial, because of how this is going, I want to continue with the hearing during the vacation. All what is required of him is that he seeks the permission of the CJ to continue. So in this matter, maybe surprised the CJ's name is being brought in as if the CJ that is ordering. Because they give the impression as if it's the CJ that is ordering the trial to continue, and they are doing that because they want to drive a certain narrative. You understand? So this is the factual. This is it. And then when you analyze this, and let me add one factual issue. So usually the judges that sit on vacation, because vacation is seen as a period for the judges to go and rest. When the court resumes, most of these judges also take their own breaks, and so the focus of the legal vacation, you understand, is so that the judges will rest. It's not for we as the lawyers to rest, because we as lawyers, we are supposed to work in firms. And so when you bring a case, yes, maybe the law on the matter, but it's as if it's a firm. And so if I'm unable to go to court, I can ask some of the lawyers in the firm to hold my brief. Yes, and so the firm itself has its own arrangement when it comes to taking leave, because mind you, law firms also work under the Labor Act. It's not like law firms act outside Labor Act. And I'm saying that the focus of legal vacation is not for us lawyers, it is for the judges. It is, we should understand that it's not for us lawyers. So any argument that seems to suggest that if I'm on leave, and so because I'm on leave, I cannot represent my client, that statement for me goes at the very heart of the oath we took as lawyers. When you are called to the bar, you take an oath. And to make an argument that says that I'm on leave, and because I'm on leave, I am unable to represent my client, it goes against the very foundation of the profession. And it's for this reason that I'm scandalized at some of the comments having been made by very senior lawyers in this country. Very senior lawyers. So I think on Tuesday, I was going when I had an interview by my learned senior, Atta. And in that interview, he's a very honest man. Because where he was sitting, I think Umar Sander thought that he was outside. He said, no, I'm not outside. I'm in Ghana. I'm not outside. But I won't come to court. That is drawing a dagger at the heart of the values and principles that underpin this our constitutional democracy. And when I say he was being honest, he could have said, oh, yeah, true. I mean, Saskatchewan. So forgive me, even though I understand that, because the judges are very courteous. See, this is about, so let's say you have court, and then you write a letter. Oh, that my lord, please, I have this emergency. I'm engaged here. Usually the judges tend to indulge us. Yes, and it does not mean that we have that right as lawyers. The judge will indulge you. You are in court, we take a date. For that reason, you can't come to court. But for you to say that I'm in the country, I'm not sick, I don't have an emergency, there's absolutely no reason why I should not represent my client as the terms of the contract between the client and myself, as the ethics of the profession demands. But this is also an ethical issue. So now I'm in the country, I'm not sick, I don't have any emergency, I don't have any reason why I can't, but I won't come to court because I'm on vacation. That is scandalous. scandalous. Yeah. And then, what even makes this matter worse is the statement by the Ghana Bar Association. It makes the matter worse because, one, us as lawyers beyond everybody else know that convention cannot supersede the law, especially when the basis of that law is the Constitution itself. And so there's a reason why I gave you that. I started with the Constitution because there's a convention, and I told the reason for the convention, and the reason being that during the vacation period, just about 30 judges sit. So there's a very high probability that those judges will not be dealing with the hearings that they are already involved in. And you see, when you are doing hearing, when you understand the elements of communication, that is, when you are giving your evidence, they look at your body language, they look at, the judge must determine whether your statement is truthful, and sometimes your body language also helps them. So there is a reason why it would not make sense for a judge who was not a judge handling the part head case, to continue with. So they limit themselves to motions. You understand? So that's the convention that usually they limit themselves to motions. But that convention, I've given the reason for the convention because of the high probability of just the 30 judges across the country, you understand, handling matters or cases which they are not the original judges for. You understand? So where a judge who is handling the case says that no, this case I want to continue even during the vacation, you understand, and makes that order to the lawyers who are not the focus for the legal vacation. Because for instance, when they are working, we are working. Have I stopped working? Have they stopped working? And as I said, litigation is just a small bit of a lawyer's job. It's just a small bit. They still go to court. They are still charging their fees. They are advising on transactions. They are still going to the lower courts. You understand? Even they are still going to the so-called the superior courts for their motions. So when you say that you are on vacation, that is a dishonest statement. That statement is dishonest, but you are still working. And GBA comes out with this statement. Say, I'll call sham of a statement. Because they know the truth, or they ought to know the truth. They ought to know. So when you make a statement that says that, listen, the focus of the vacation course is just to hear motions. It's one of the collectors of Order 79 Rule 1. What's the meaning of causes or matters? Causes or matters does not mean motions. It does not mean interlocutory matters. It means all matters. All matters. So when you come out with this statement, issue this statement in a matter that, in my opinion, people want to hear Ghana GBA's opinion on this. Like they want to hear lawyers' opinion on this. Even though I think that when you read Order 79 Rule 1, because right now everybody has said, now something has said Order 79 Rule 1, you can understand the matter for yourself. You don't need to come and see me, so I'll charge you fees for the interpretation to give to Order 79 Rule 1. It's very clear. But when a professional body, that's why you are a professional body, when you consider the high reverence this our constitution gives to this professional body, because for instance, the GBE is a professional body, it's a club. You understand? Then, like the scripture said, to whom much is given, much is expected. You understand? But immediately GBA start descending and start giving statements that lays credence to a view that they have partisan interests. They are undermining their role in this nation building effort, in building not just the right political culture, but I've argued elsewhere that we also need a right constitutional culture. That constitutional culture will dictate that our loyalty are to the principles and values espoused in our constitution. You have to have a professional body that has been given high reverence by constitution by saying that there are certain positions that or certain roles that has to by force come from the GBA. And then when you do not consider that and consistently be issuing statements that makes us question, then it is a worry. Now, when you put all this together, then the question you ask yourself, what interest? Why have they taken this position? Because clearly, they understand this authority of the CJ. And I'm saying they understand because you record that in 208, Honorable Atta was ready to go to court on a Saturday to challenge the validity or not of an election. You all record that. Now on Saturday, what authority would he have or would any court have to sit on a Saturday? That authority will come from the law that says that the CJ has the power to cause a matter to be heard on what? Any day. On any day. So it's the same principle. Maybe the activity may be different, but the activity emanates from the same principle. So if you make this argument, then that means that, so you know, that means that you are not being principled. Then the question is, why would they do that? Why would people who know, who have taken advantage of this principle to pursue an action, suddenly turn around and indeed are ready to go to the Supreme Court to seek interpretation and create a storm where indeed there is calm? They create a storm. Why would they do that? They will do that because of the party they are from, and because the party they are from has fundamentally lost its focus. They have fundamentally lost their fidelity, their sense of fidelity to the ideals, the principles of Ghana. That's why they will do that. That's why they will do that. Immediately you do politics that is premised on convenience as against principle, then you've lost it. Then you've lost it. Because why are they doing that? Now they are doing this in spite of the clear position of our constitution that says that one of the abiding principles that ought to underpin this constitutional democracy is the principle of what? Probity and accountability, and that all justice emanates from us the people. And indeed the judiciary, when they dispense with justice, they are dispensing with justice for us the people. And this clear principle is especially seen in criminal cases. There's a reason why in criminal cases the title of the case is the Republic versus Asumisi. So somebody who happens to be in their party undertakes an activity against the clear terms of our laws, an activity whose consequence potentially can lead to the extermination of all of us, an activity that we all say constitutes an existential threat to Ghana, an activity the president they sponsored made Ghanaians to believe that it was so critical to him that he was ready to put his presidency on the line. You understand? And deliberately took steps to amend the law to enhance the punishment regime for that activity, to make us believe that he has an unalloyed commitment to the fight against that. And a member of their party has been squarely caught within the confines of that law. We hear, surprised, I hear arguments that conviction was a political one. Why? Because there was no mens rea. And I'm scandalized because Criminal Law 101 says that there are two types of crimes: crimes mala prohibita and crime mala insi. Now, what's the difference? There are certain offenses whose basis is morality, and so for those offenses, we cannot say you are guilty unless we prove a negative state of mind. Those are crimes mala insi, and those crimes, for you to succeed on the conviction, that you need to prove not just the act, that's what we call actus reus, but you also need to prove the negative state of mind, that's the mens rea. Then we also have some crimes that are not premised on morality, are premised on the desire to keep public order and peace. And those crimes, we say they are crimes mala prohibita. Yeah, you understand? And for those crimes, you don't need to prove mens rea, just the act itself. So when we had a law, the law said that, listen, where you have a concession, you cannot assign, you cannot create a mortgage, you cannot transfer, you cannot cause any activity on that concession without the clear consent of the state. And then within that act, we say that, so they came to amend and put it there, that any breach of this act constitutes a crime, and a criminal regime is given. That if you fall under, you contravene, then 15 to 25 years. The guy goes to court and clearly he had the concession. Clearly he called somebody to come on the concession. Clearly that activity was done without the consent of, and this person has been convicted within the clear terms of this act. Due process was had. And yet you have this political party who are meant to help play their role, be faithful, be fidel to the principle of probability and accountability, to the well-being of the people of Ghana, to be faithful to Ghana. Spin the story and say that it constitutes political crime, and then go on the streets to demonstrate and call that demonstration an attack on democracy, and choose a date where 8 of our compatriots lost their lives. You understand? In an attempt to go to a program whose focus was to find solutions to fight this activity, which all of us agree constitutes an existential threat to the people of Ghana. I'm not deviating. This guy, and you're not supposed to be doing this. No, I'm not deviating. I beg you, don't be. Last to Kyea, he was misbehaving. In spite of the clear rules of this program, he was misbehaving. I beg you. Today, Senator, he said, you can't do that. You can't be interjecting. Yes, so don't be interjecting with your hands. It won't happen. Let me be focused. You understand? Do this. Now, what does it mean? They are fighting against Ghana. They are fighting against the principles of probity and accountability. And they don't mind using any weapon, including deceiving us on the interpretation and application of legal vacation. They don't mind doing that. And so what's the essence? So all what they are doing in their mind, they think it can enable them to dodge probity and accountability. And they do not mind, in spite of the clear terms of Article 55 of our Constitution. They do not mind. Let's read Article 55. I don't have some sort of, let's read Article 55. With permission, let me use it. Let's read Article 55. Because it's time Ghanaians start to measure political parties and hold them to a very high, and where they are not performing out to, we must sack them. When you read Article 55, see NPP, you see NPP, the founders people, they don't want us to read it. Who will read it? See, the right to form political parties is hereby guaranteed. Every citizen of voting of Ghana or voting has the right to join. Subject to the provision of this article, a political party is free to participate. Listen, subject to the provision of this article, a political party is free to participate in shaping the political will of the people. 1, to designate information on political ideas, social and economic programs of a national character, and sponsor candidates for elections to any public office other than district assembly or lower local government units. Now I say what? To designate information on political ideas, social and economic program of a national character. And that's what I've always maintained, that one of the critical political institutions that ought to play a critical role in our forming the right political culture is the political party. So when you have political party that can demonstrate, and one of the reasons why I consider we have the right to demonstrate, because demonstration is one of the ways in which you shape political ideas. You understand? To tell Ghanaians that where the power that as Ghanaians we give to the cause, you understand, to convict people who are violating the clear laws of the land, it constitutes political imprisonment. Then what are they doing? Then they are fighting against the collective will of the people of Ghana, because they are designating information or misinformation whose focus is to draw, is to push a dagger at the very heart of this constitutional democracy. And then you consider that in that so-called petition, that sham of a petition, have you read the petition? Why they did that demo was attack? When you read the petition, and that due process was not followed, and that dates, have you read the petition? Have you read this program? You can't interject.
Please.
I told you last 2 weeks, Mojib came to this to misbehave. You were not here.
Please go ahead. Allow it.
No, you are talking. So you interject.
Go ahead.
You interject.
No.
You see, so that you see, where you are a member of the new patriotic party, then clearly you are fighting against Ghana. You are fighting against the ideals of Ghana. Mojib, you are fighting against the ideals of Ghana. You are fighting against the values of Ghana. You are fighting against the principles of Ghana. You understand? It's become an association. You understand? That seeks to use public power to advance their personal agenda. And that is what has happened represents. And the disappointing bit is that it's being led by senior members of, not just of their party, but of this country. People that you would think that would lead this agenda to build this strong Ghana. And Ghana should wake up, we should open our eyes. Because we are at a very critical stage of our national development, national agenda. We should open our eyes if truly our commitment is to build that society where we all have the right to pursue our individual ambitions, where there shall be equality of opportunity. You understand? Where all children can have a place of dignity to lay their heads. Where we won't have school under trees. You understand? Where Galamsey will be a thing of the past. Where our individual ambitions will have the best opportunity of being met. I can tell them that if that's truly our focus, then you'll be fighting against our agenda if you go and join the new patriotic party. So to end, you see, there's a reason why we took upon ourselves this constitution. And the reason we took upon this constitution can find itself in a preamble, can find itself in the oath the president takes. And clearly the focus of this constitution is to create a country where our right to life will be guaranteed. And when we say our right to life, it's not that shall not kill. Where our right to life includes a life that has dignity. Understand? A life that will have proper education, everybody. A life that will have proper health care. You understand? A life that can bring you happiness. A life that will give you the chance of pursuing your own ambitions. You say that this constitution says that one of its purposes is to give us is to grant our right to pursue our liberties. So you can be free to speak your mind. You can be free to demonstrate, but that demonstration must be in the interest of the country. You can be free to associate. You can be free to watch Alaji in the morning. You understand? And the last purpose is that so we have a right, you can have a right to pursue our own happiness. So when anybody is doing what the NPP is doing, then what they're actually attacking is not just the constitution, but the reason why we took upon ourselves our constitution. You understand? So we should wake up, because nobody can protect the constitution, can protect the ideals of this constitution, can protect the values and the purpose of this constitution than the people of Ghana. And that battle will not end if we do not destroy anybody, including any political party, especially the new patriotic party, you understand, because they are fighting against our collective interests. Thank you. PENDREAM TV. Now, so far so good. Say open online portal lewo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.